The next case is in re BT. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. You can refer to them by terms like the child or initials. We've read your briefs and are prepared to proceed when you are.
Good morning, Your Honors. May it please the Court. Joseph Schell, on behalf of the juvenile BT, the appellant, and Summit Legal Defender's Office. Your Honor, I'll reserve 2 minutes for rebuttal.
Thank you.
When the victim says that the defendant's conduct didn't cause their economic loss, the trial court errs in ordering restitution for those losses. That's the error that the trial court committed here.
That's not what happened. The victim didn't say, this person didn't cause my loss. The victim said, I suffered loss in June, and here's what happened. So the victim didn't say, well, this person didn't do it. There's a dispute about what happened here, but the victim clearly didn't say this person didn't cause my injuries.
So I suppose that's right, not in so many words, but the victim did say two things that effectively say BT did not cause the damage that they were talking about at the restitution hearing. So first, on transcript page 7 of the restitution hearing, the Cementech, the victim's representative here, said, I was working before this weekend in June, I walked the lot, I did not see any damage. Then on page 26...
I think the record is clear that the victim said this damage happened in June of 23 or 4.
23, yeah.
I thought it was 23.
Yeah.
But I think that's clear now. I would agree with your point there, that's what the victim testified.
Yeah, and then it further said, though, also on page 26 of the restitution transcript, that every single piece of property that it was talking about, and I guess this is the same point, right? Every single piece of property that it was talking about was damaged over that weekend in June. Now, the uncontroverted fact also is that BT was not there in June. His allocution was that he threw a couple rocks at a couple windows and that he did so no later than the beginning of May. The government did not object to that. The magistrate made a finding that BT was not there over that weekend in June, right? The magistrate said, quote, he was a whole separate day or event. That's on page 42. And on page 47 of the restitution hearing transcript, the magistrate also found the whole thing at the plea was that he was pleading to a different day. That's what I find.
He was admitting, I should say in the juvenile setting, he was admitting to conduct on June 19th.
No.
That's what the complaint was, June 19th.
That's what the complaint alleged, but what he admitted.
Now he admitted to that, but then he wanted to say in addition, but I didn't really do it then. I was there in April or May, as you said.
Yeah, so I don't think he admitted to doing anything in June, though. That was the charge, is that he was charged with vandalism over that weekend of June in 2023. But what he admitted to was criminal damaging no later than the end of April, beginning of May. Right now, the date for criminal damaging is not an essential element of the offense. No one's argued that it is. Right, that's the fact, and that's the finding that the magistrate made that was unchallenged by the government then. It's unchallenged by the government here on appeal. There's just no question that the only thing that the only criminal conduct BT was convicted of was criminal damaging at the end of April, beginning of May. Now that all happened.
I want to go back to your assertion that date is not an essential element.
Mm-hmm.
Isn't it when you charge a crime, the state has to also establish venue, identity, date. So how do you say that it's not essential when we're talking about, I know we're talking about connecting it to restitution, but if he admits to criminal damaging within some date, isn't he admitting that as an essential element?
So no, I want to be clear, he never admitted to doing anything in June, right? What he admitted to was criminal damaging at the...
He admitted to the complaint.
To the complaint.
There's no language in the plea transcript that he admitted to the complaint. What he said is, I did the criminal damaging...
What would he admit to if he doesn't admit to the complaint?
Well, he admitted to the criminal damaging crime, right? He admitted to that's the identity of the crime. I mean, the date when it happens doesn't change the identity of that offense, and I think that comes out of this court.
There's a specific charge that says on this date you did this, and he admitted to that. I appreciate what your argument is. I mean, and I get there was some debate about that, and the record is what the record is, and there's some clarity from what the magistrate talking about.
Mm-hmm.
But a simple fact is you admit to a complaint. That complaint says this occurred on this day.
So yeah, I mean, I think we'll probably go around in circles for some time on this. I agree that that's what the complaint said. I think the record speaks for itself that he did not admit to that complaint. What he admitted to was criminal damaging at the beginning of May. And I don't have the cases on hand. They are in the opening brief, and I think in a reply brief as well. Both this court and other Ohio appellate courts jurisprudence, Judge Lanzinger, that the date, unless there's something relevant to that specific date, like the age of the victim, for instance, or if it's relevant to a defendant's alibi, that date is generally not an element of the offense. And so that if conduct is proved that it happens on a different date than is alleged in the complaint, there's no problem with like a conviction, say, right, if that went to trial and they're like, oh, we find that you did criminal damaging, but it was on June 2nd, not on June 16th. So long as the evidence supports criminal damaging on June 2nd, there's no problem, there's no even notice problem,
Well,
really.
does they need to amend though in those circumstances? If that's what the evidence shows, they need to amend our complaint to say, you know what, now at trial the testimony is this happened in April,
Yeah.
we're gonna amend our complaint to say this happened in April, not June.
Yeah, generally speaking, not necessarily. Again, unless the date is somehow relevant to an element of the offense, right? So if we're talking about some sort of sex crime and the victim has to be under 13 for it to be enhanceable or something, then the date would be relevant, to the extent that the victim's age was in question. If there's an alibi, presented from the defense, there's a case that, I just wasn't there on that date, then the date is relevant. For that purpose. But generally speaking, no, because the date generally doesn't change the identity of the crime. Is again, I don't have the case on hand, but it's in the briefs. That's typically the case. And I think that's what we have here. Is he said, I did this conduct, right? I did the criminal damaging conduct. It just wasn't on this date.
To move on to a different subject.
Yeah.
It sounds like the decision talks about them finding the damage on that date, June. And then it sounds like someone mentions that it's in storage or something like that. So I think what they're saying is the connection could be that even if he admitted it was in May, that the damage wasn't found till June. That doesn't lose the nexus. I mean, is there some merit to that?
No, Your Honor, because of what the victim testified. So I agree with you. That is how the trial court read the victim's testimony as well. They just didn't discover it until later.
Right.
But the victim's testimony forecloses that factual finding. There's no evidence to support that because, again, of what the victim said, I was working before this weekend in June. I did not see any damage before that.
I'm just saying I didn't see it at the time. Doesn't mean it wasn't there. It was in storage or something where he wasn't expecting it. Is that? Well,
maybe on its own. But again, what the victim also said is that everything that I am talking about today, every single piece of property, was damaged in June. And that, I think, right, even if that first statement leaves that door open a crack, that second statement closes it firmly on, no, that's not, the victim did not say, well, we just found this damage in June, right? I think the combined effect of those statements is that this damage that they were talking about, that they were asking for restitution for at the restitution hearing, that only happened over that weekend in June. Right, that's what's saying I didn't notice any damage before that, and everything that I'm talking about here that I've presented evidence of the loss happened in June. Right, and so without anything else, there's no competent, credible evidence to support a finding that this was just latent damage that wasn't discovered until June, because the victim said that's not what happened.
On a simplistic level, excuse me for being simplistic here, your client admitted to breaking windows and windows were broken. How is it an abuse of discretion to say he shouldn't be responsible for some restitution?
Well, because there were 3 other juveniles who were charged with also vandalism, criminal damaging, and more serious offenses over that weekend in June. And the law.
Now, I read that. Was he in any way acting in concert with these folks, or is this completely different circumstances where we have him doing stuff and these other 3 people coincidentally at the same place breaking windows? That was not clear to me from the record.
So
is it clear from the record what we're going on?
yeah, I think I agree that that's not clear from the transcripts. From the discovery and everything that was presented, that was exchanged between the parties in the trial court, is that it's clear that BT was not there. There's some body cam footage of even these other charged
Is that
juveniles.
when they discovered? Is that in the record before us? And I appreciate you're saying discovery, that may or may not be the record. Going through the record, are there documents that let me know whether these folks are in any way acting together or separate?
No, not documents that were presented at the hearing. No, they're representations from BT's trial counsel to that effect, right? We've reviewed the evidence. There's, we've got body cam footage of these other juveniles saying BT wasn't there.
In all due respect, unless you supplement the record,
Fair enough.
that it is what it is. The
Absolutely.
record is what we have before us. So if your representation of the record is not clear, thank you for that.
Absolutely, and I think right, what we do have in the record though is there has to be, right, the law requires competent, credible evidence that shows that there's a direct and proximate result from the conduct that this person was convicted of that ties it to the economic loss that's claimed, right, that there's evidence for, that's claimed at the restitution hearing. And when the victim says everything here was damaged in June, right, that's the same as saying nothing that we're talking about today was damaged at any other time. And the fact of BT's allocution that the magistrate accepted, and there's been no factual challenge from the government at any point in this case, is that the criminal conduct that BT was convicted for occurred no later than the beginning of May. So when you put those things together, there's just no competent, credible evidence to establish that causation requirement, the direct and proximate cause, between BT's criminal conduct that he was convicted for, not charged with, but convicted for, and the actual economic loss that was claimed by the victim in this case. I think there are similar flaws with some of the other trial court's factual findings, right? Is that, the same thing goes for what it said about that there were pictures of, the vehicles that BT damaged submitting into evidence. No, there were pictures of vehicles that were damaged over a weekend in June that were submitted into evidence. Right, and we've already talked about the trial court's finding that these damages just weren't discovered until later, right? The victim's testimony.
Looking at these evidentiary standard, or evidentiary findings, would that be an abuse of discretion standard? What would our review be for those findings that the court made in this case?
I think for those specific findings, it's abuse of discretion. I do think that there's a question about just the trial court's application of the statute in general that raises a de novo question here, because we're talking about essentially BT being held responsible or being ordered to pay restitution for conduct that he wasn't convicted of. And that's the conduct in June as opposed to the conduct that he admitted to doing in May. And so the cases that we cited in the brief, State versus Hume, State versus Standen, both from this court, right, say that Hume in particular, specific to the restitution statutes, that when you're alleging that that you've been made to pay restitution for something that, in that case, it was a theft that he was charged with, but not that he was convicted of. So similar things here, right? That's a question of law. But as to these specific findings, I agree with Your Honor that it's an abuse of discretion. And when there are no facts to support those findings, then that has to be an abuse of discretion. And particularly when you've got a witness here whose testimony is not challenged, is uncontroverted, right? There's no contrary evidence that says actually this stuff was damaged in June. We only have the victim's testimony that says, that it wasn't damaged, or that it was damaged sometime other than June. We only have the victim saying this was damaged in June, it was only damaged in June, and we have the magistrate's factual findings, which is supported by BT's elocution, that BT wasn't there at the time that we're talking about this damage occurring. And so because those are the only facts the trial court had before it, none of those support the factual findings that BT caused this June damage. And so for that reason, we would ask the court to reverse the trial court's restitution order. Thank you.
Good morning, judges. May it please the court, my name is Rick Raley. I'm appearing today on behalf of the appellee of the state of Ohio and Summit County Prosecutor Elliot Polkovich. I want to jump off a little bit of the questions that Judge Stevenson was just posing. In my view, this is a very simple case. We had a delinquent admit that he damaged 2 truck windows. There was a hearing and there was evidence received about the cost to replace 2 truck windows. And the trial court then imposed restitution in that amount. That seems like a very reasonable exercise of discretion. And I don't think there's any law that the delinquent can point to on appeal that says that's an abuse of discretion. So I think that is the simple basis from where you really jump off on, and there's really not much to say besides that.
Is the record at all clear about this incident? There's other people damaging property and this individual damaged property. Is there any real explanation in our record before us as to what happened?
Since it's an admission, Judge, there is not a whole lot of factual development in the record. And quite frankly, if there was this kind of factual dispute, then there should not have been an admission, there should have been a trial. And the restitution should not be used as a way to then challenge elements after an admission. The restitution hearing's purpose is to establish the amount of restitution. It's not to parse out particularized damage that can be attached to each single delinquent involved in a case. It's a discretion standard. And it's also in juvenile court. I think it's very difficult to accept the absurd result that you can admit to a crime and then there is absolutely no restitution attached to that. What kind of message does that send to an alleged delinquent in Summit County?
Did he admit that when he gave his statement, did he state that the windows were already broken when he threw rocks through them?
He said, I broke a couple of windows. Some of them were kind of broken too. He kind of prevaricates there. And the question is the admission the important part or the allocution? The admission was to the charge in the complaint, which was amended. The date was not amended. That is important to note. And he admits to, I damaged something. And there's a hearing where there's a whole bunch of damage brought up. And there could have been, who knows, based on what the factual record before it, there could have been a determination that he was responsible for all of that. The magistrate gave him the huge benefit of the doubt by picking the cheapest truck windows that are damaged and saying, no, I'm only going to make you pay this. There's a lot of, I appreciate that this court is now using the language from State versus Weaver about the abuse of discretion standard. Does this really show a perverse will or bias or passion on the trial court's part? I can't see that anywhere in this record. So unless there are any questions, I'd ask that we affirm. I think this is a firmly well-regarded, well-reasoned decision about how to order restitution. Thank you.
Okay, so I have 3 quick points on rebuttal. One, just to your factual question, Judge Stevenson, yes, he said the windows were already cracked. That's part of his allocution on pages 8 and 9 of the plea transcript. Second, the state's contention that it's not the trial court's job to parse out damage for restitution, that's absolutely the trial court's job. That's what the law is. That's what Yerke says. That's what the statute says, is that it has to be directly and proximately caused. Yerke says that you can't order restitution for anything that's not a natural and continuous consequence of the criminal conduct that someone is convicted of. And it has to be that specific conduct, right? Just at paragraph 16 and 17 of Yerke, it gets into just how specific we're talking about, and it is the exact actions that someone was convicted of. So that is absolutely the trial court's job. It is not like the state was surprised here by the different dates in the allocution as opposed to what was charged in the complaint. There were 6 weeks in between the plea hearing and the restitution hearing. During that time, all the state had to do was ask for evidence of damage that was done during the time that BT said that he did damage. There are a number of inferences. I've listed them in the reply brief, right? There's 3 inferences from what we've got here, and all of them lead to the same place, is that there's no evidence that anything was damaged on the day that BT said that he committed the crime of criminal damaging. And lastly, my third point is that as far as the magistrate giving him the benefit of the doubt on the cheapest windows, it is an abuse of discretion to just pick something out of the ether and say, well, we've got all these windows, let's just pick 2. I don't really care if it's the ones that this person broke on this day or the ones that some other person broke on some other day. That is the definition of an abuse of discretion. It's an arbitrary decision that's not tied to BT's criminal conduct here or to the victim's testimony about the damage that it suffered.
I have a question.
Yes.
It's been a while since I've been a trial judge, but my understanding of the law, maybe you can tell me where it is in the code, or if it's in there at all, is that you're not allowed to get restitution for something that's covered with insurance.
Yes, that is correct.
So it sounds like the restitution total came to happen to be the same exact total of the deductible, but without that reasoning, and technically these windows were covered with insurance money for damages. So is there an issue here that maybe the judge abused her discretion when she's ordering restitution for something that was covered through insurance?
I absolutely share your concern. But I will also cap that we did not raise, that as a specific argument. But it was an issue. I don't know how much your honors know about what this case went through before we arrived here. It was flagged for mediation. There were some mediation meetings. I don't want to get too much into the substance of those. But insurance coverage was an issue during those. We weren't able to resolve it through mediation. I agree with you that that's a concern about whether they're getting, I know the state likes to use the word windfall. If there's a risk of that for anyone here, it would be for the victim, collecting both from these juveniles and from the insurance company. I think that is a concern. I will say we didn't raise that as a particular argument here, just sort of given the facts in the record. We think it's clear that, if you're not there, you can't be made responsible for damage that occurred when you weren't there. So if there are no other questions, then we'd ask your honors to reverse the trial court's order of restitution. Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail a copy of the decision on the day it's released, and the decisions are posted on the Ohio Supreme Court website. Thank you both again. At this time, the court is now adjourned.